Welcome to Engaging Experts, the podcast that goes behind the scenes with influential attorneys. Our guests will describe their practice and expertise. Then we will go deep on various topics related to effectively using expert witnesses.
All right, welcome everyone. John Corkin here. I am the co-host of this show, and I'm excited because today we have with us James Blick, who's one of the principals and founders of Erso Capital, also involved in TheJudge, which is a litigation financing company based out of the UK. He's the head of US operations. He's an expert in litigation financing, and we're going to be talking all about that. So if you are an attorney and you are involved in litigation in any way, this is really a critical piece of the puzzle that you'll want to know more about. So we're going to dive into that topic.
This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
All right, James, I'm excited to interview you here today. Let me first tell everyone about your background. So you co-founded Erso Capital in 2020. You are based out of their Southern California office down in Irvine. I'm recording this up in San Francisco, so we're in the same time zone in spite of our accent differences. And you sit on the Erso board and investment committee. You are also a director of TheJudge, part of the Thomas Miller Group since 2019, which provides highly specialist litigation insurance products to commercial plaintiffs and law firms. You have 15 years of experience in the litigation financing industry. And after law school, you worked at a major legal expenses insurance company in London, where you handled complex litigation claims. Afterwards, you joined the Judge Group in 2008 and went on to set up TheJudge's California office and head up its U.S. division. And of course, you've spoken a lot on this topic of litigation finance. So let's start first with, for those who aren't too familiar with what litigation financing is and how it works, why don't you give us a quick overview just to orient all of us?
Sure. Thanks, John. Very happy to. So litigation finance is essentially the business of providing capital, primarily and most commonly for the purpose of funding litigation. This type of activity is often described as non-recourse financing. The idea is that we would provide capital to fund the legal fees and costs involved in a potential lawsuit. If the lawsuit is successful, then we would be entitled to be repaid the capital invested plus some return on that invested capital, usually from the damages or the settlement obtained from the lawsuit. And if the lawsuit's unsuccessful, then we would lose our invested capital and would not be entitled to recourse. So the idea is that for example, a company that's perhaps in some financial distress, but potentially has a valuable claim that it needs to pursue against a third party for breach of contract issue or some other issue, could come to us, could obtain funding, use that funding, fund the legal fees and expenses involved in pursuing the claim, potentially using funding for other purposes, such as working capital for the business, but during the life of the litigation, for instance, and do so without having to take on traditional, full recourse debt facility, secured against other assets of the business. And so that's the kind of the general premise of litigation finance. It can be facing either the plaintiff company that's involved in the dispute, so funding to the company to enable the company to pay its lawyers. It can also be used by law firms themselves that want to take a case on full or partial contingency, but want to share in the risk and the cash flow with an outside capital provider. And so the funding could essentially sit behind the law firm, provide the law firm with working capital during the life of the dispute, and then the law firm would be responsible for paying a return to the funder from in the event that it succeeds in recovering a contingent fee.
So it sounds like what it does is it enables both companies and firms, which otherwise wouldn't be able to take on a case with perhaps a valid claim or valid potential claim, to take on that case and to pursue it.
Absolutely right. Yeah. So there's definitely kind of an access to justice component. Where a party or a firm that just wouldn't be able to pursue a claim absent a source of capital, or might be able to initiate a claim but would be forced to sort of compromise at a very early stage because they just wouldn't have the resources to see it all the way through trial if necessary. So litigation finance is definitely a way to open up access to what can be often costly and long-running litigation for parties that can't afford it. But there is also a more of a sort of cash flow management and a risk management aspect to it. So a lot of the counterparties that we would get involved with are not necessarily financially distressed. Maybe they're in large, well-resourced companies, particularly in the current climate, maybe have some budgetary constraints or a cautious attitude to risk and investing their own resources in litigation. And so litigation finance can be a way for entities like that to take the cost of litigation off balance sheet and essentially transform what would be initially a cash drag for several years while the dispute is resolved to something that's cash neutral in all circumstances, unless and until a recovery is achieved, in which case, cash positive. So, it can be a useful financial tool for all types of business, both those that are sort of financially distressed and need funding, as well as those that, don't necessarily need it, but, may find it a valuable alternative way of paying for legal disputes.
Great. And so, probably a related question is you handle attorney fee insurance as well, which I imagine is helping companies to mitigate the risk of a big verdict or settlement with a large attorney fee component. To talk a little bit about what's involved in that and how that helps companies.
Yeah, sure. So attorney fee insurance is one subset of a kind of what I would loosely categorize as a suite of insurance products that we would call litigation insurance. And so, deliberately drawing the parallel there with litigation finance. This is a class of insurance which is structurally very similar to litigation finance, with some important distinctions, done through a regulated, licensed insurance framework, and with some offering different economics. So attorney fee insurance specifically is a product that can be taken out typically by a commercial plaintiff involved in a lawsuit, either anticipated or pending lawsuit. And the idea is that the insurance covers the plaintiff's own litigation budget risk. So the plaintiff will self-finance their legal fees and or expenses during the life of the case. But if they lose the case, or the case is unsuccessful and they don't obtain the settlement or the damage recovery they expected, then the insurance policy would kick in and would effectively reimburse them for some or all or an agreed portion of what they've spent. So it's similar to litigation finance. The real difference is that it's not providing cash flow to fund the legal fees and expenses on a day-to-day basis. It's an indemnity for those kind of wasted expenses if there's an adverse outcome. And so as a result, it has sort of similar dynamics to litigation finance, but ultimately different economics. Typically, this type of insurance works on the basis of an initial premium that's paid when the insurance is taken out, and then a second premium which is paid only in the event of success, which is similar in concept to a non-recourse funder's return, but different in economics. So it's the contingent portion of any premium is a small fraction of what somebody would pay to a funder for providing capital. And so the idea is that if I'm a business that's involved in a dispute, I could go down the litigation funding road, and that would be the kind of somebody else providing both the capital and taking the risk in terms of the legal fees that would need to be incurred. But I'm going to pay fairly substantial return to that capital provider because they're taking all of that cash flow and all that risk. An alternative approach is that I could self-fund the spend, take out an insurance policy that will cover my risk if I'm unsuccessful. So it kind of puts me back in the same risk position I would have been in with litigation finance, but I have to wear the cash flow during the life of the litigation. But the trade-off is that the amount that I would have to pay to the insurance company is much lower than, in the event of success, is lower than I would have to pay to a funder. So really it's just an alternative, litigation finance, litigation risk management tool, and either an alternative or a complementary tool to litigation finance.
Makes sense. Okay. So I have a bunch of questions that I want to ask you about, but you mentioned in the context of litigation insurance and attorney fee insurance, you said it could be related to a pending claim or anticipated claim. Mm-hmm. I'm wondering, is that the only circumstances where companies obtain this type of insurance, and what types of companies are obtaining it? And do they ever do it just as an ongoing course of business? Are they getting litigation insurance earlier on without any pending claims, just as a way of protecting their bottom line?
Yeah, that's a great question, actually, and it highlights, I guess, one of the sort of slightly unusual quirks of litigation insurance by comparison to more traditional liability insurance. So, in a traditional liability insurance scenario, casualty insurance, I buy insurance to cover me from the possible future risk of litigation. So, if I'm a law firm in private practice, I might take out insurance to cover the risk of malpractice claims against me, or in the same way that any company might take out that type of liability insurance to cover possible future litigation risk. Litigation insurance is kind of unique in that it's intended to cover existing litigation risk. So it's intended to cover the outcome risk of existing litigation exposure. So if I went to my traditional liability insurer and I said, I want to buy some liability insurance because I'm suing these guys or they're suing me, the liability insurer is going to say, well, we're not going to cover that because your house is already burnt down, so it's too late to buy insurance for that risk. We can write you a policy for future risk. So that's the sort of the key difference between litigation insurance and liability insurance. And in the UK, this type of insurance has sometimes been sold under the banner of ATE insurance, which stands for after the event insurance. And that's to highlight the fact that you take it out after the event. You take it out after the dispute has already arisen. Now, there are lots of different, there are lots of kind of specialist litigation related insurance products that can be structured kind of in the way you described, cover potential future litigation risk. But when we're talking about attorney fee insurance and everything else, which is kind of under the sort of banner of litigation insurance, we're typically thinking post-event. Either a dispute has already begun, or at a minimum, there are already circumstances which may give rise to a legal dispute.
Makes sense. Okay, so it's kind of the train has left the station, it's further along for you. And so my next question is, how do you evaluate all these different types of companies that are coming to you? Certainly, I'm sure your background, your experience in complex commercial litigation is tremendously valuable, but you are involved in so many different areas, IP, antitrust, you name it. How do you evaluate these claims? It's
a great question, and something that obviously occupies a lot of our time and energy. We absolutely don't purport to be experts in the range of areas.
You must be okay at it, or else you'd go broke. So.
I think what I would say is I think we understand litigation / arbitration dynamics very well. So, we within the group have been involved in, so many different types of disputes over so many years across so many jurisdictions that, there are certain sort of commonalities, I guess, that all types of, particularly in the kind of, in the commercial litigation space, which is where we focus. There are sort of some commonalities. There are features of any dispute that would make us interested, features of any dispute that would make us concerned. And so I think there's an awful lot of general litigation dynamics, I guess, that goes into thinking about whether something is worthwhile. I mean, in terms of the types of disputes that we would be interested in funding, we are primarily on the plaintiff side, simply because the economics of these deals sort of require or assume a substantial monetary recovery at the end of the day if we're successful. That's not always the case, but certainly the most common dynamic. And so, we'd be wanting to think about, the legal merits, the reliability of the venue, the jurisdiction where we are. We'd be wanting to think about damages analysis, the level of the legal spend that's likely to be required to get to trial, the economics between expected recovery and legal spend. We'd be wanting to think carefully about who the opposing party is and, what information we have about their financial resources and their ability to actually pay a settlement or an award in the quantum that we would expect. We would be wanting to think about the expertise of the law firm involved, on both sides of the dispute. So, I guess there's a number of sort of things that we would be thinking about in any dispute. We also like to kind of understand and think about the story a little bit. Think about the equities of a particular situation. Something that somebody might have a sort of a technical legal argument, but we really feel like they're the bad guy in the dispute. That might not be somebody who would be interested in funding, even though they might have good legal merits. So I think there's an awful lot of stuff which which is more about the sort of general litigation assessment than very, very acute specialist subject matter expertise in construction law in Toronto or something. But then how do we sort of get from that to making a proper evaluation of a specific matter, which maybe has some of these kind of, either specific areas or aspects? The short answer is we outsource. So prior to any final decision being made, we would be obtaining an external legal opinion from somebody with specialism in the area, from a panel of law firms and counsel.
Oh, wow. So you hire another law firm for their expertise to come in and evaluate it and
exactly
give their assessment. Interesting.
We would get, we tend not to, invite external counsel to do a full detailed ground up analysis. What we're really trying to do is just fill in the gaps in our own expertise. So, we would want to feel good about an opportunity in all respects, subject to then just having somebody come in at a fairly advanced stage and just look at it and say.
You were saying that you bring in outside experts. So you bring in outside other counsel to evaluate your claims. Exactly.
So we would never hope to be able to have in-house all of the range of expertise that we would need. So what we would do in-house is kind of evaluate the sort of the overall opportunity and the sort of the general litigation dynamics. We might well have good subject matter expertise in-house, but then certainly prior to making a final investment decision, we would want specialist external counsel that has direct expertise in that particular subject matter and jurisdiction to just come in and look at our analysis and just make sure that we haven't missed anything, or that there isn't some case authority that we're not aware of that actually is really very meaningful that somebody with that level of expertise would be aware of. So the short answer is we would bring in some external expertise for the particular area, just to make sure that we are on the right track and haven't missed anything.
And so let's say that I'm an attorney heading towards trial. I'm considering using you guys. How involved do you get involved from that point going forward? How involved are you? Are you involved, and do I lose any of my freedom over controlling trial strategy?
That's a great question, and the short answer is we work very hard to make sure we are not taking over control of the decision making process of the case strategy. We are here to provide capital. Obviously, as part of that arrangement, we want to be able to keep an eye on our investment. So, we want to be able to have access to counsel and be able to have a conversation from time to time and understand how things are progressing. Things that we would be perhaps particularly focused on are, budget and the run rate. If we've committed to provide X amount of capital to fund a case through trial, we'll want to sort of check how the run rate is against our budget and our project plan and our assumptions. And if the case is, running way over budget, want to know about that before we run out of money. So, there's a kind of a monitoring aspect. But when it comes to choice of counsel, strategic decision-making, settlement authority, things of that nature, we do not take control. We are very much, an interested third party that, is very interested to see how all that plays out, but ultimately has no control or ability to make those decisions, and that's
not involved in the negotiation or anything like that. Okay,
absolutely not. No, exactly. So, and that's a really important thing, I think. Particularly, for a company that's thinking about outside finance, they really don't want to be able to be losing control over the way that the litigation progresses, the points at which a settlement, may make economic or commercial sense for them as a company. So it's very important that all of those things remain with them. And then from a conflict management perspective, it's very important that their lawyers who are running the case for them are their lawyers, and advising them and owe duties to them and not to us. As I mentioned before, if we need external legal advice, we'll get our own advice from our own lawyers, but they won't be involved in running the case in any way.
What about, you mentioned running out of funds? What if a case runs out of funds earlier than expected?
Yeah, that is a great question. That's definitely something that we think very carefully about when we're going into a potential matter. So the short answer is we really want to avoid that happening to begin with. If that happens, then we've got it wrong somewhere along the line. So
I'm sure it happens, though, right?
It absolutely does, and often with very good reason. I mean, a budget, like for any project. And litigation is a project like anything else. A budget is just that. It's based on certain assumptions, but nobody knows how things are going to play out. The opposing party can be hyper aggressive and force us to address countless motions that we didn't expect to, and therefore the spend cannot always be predicted with accuracy. How do we deal with that? Through a number of different ways. Firstly, when we're looking at a funding commitment, we always try and make sure that there is some margin to allow for an overrun. We kind of assume everything takes longer than expected. Everything costs more than is expected, and just kind of build that into the funding deal so that we're not trying to sort of shoestring the budget. We're trying to make sure that there is ample capital available, with often with some additional capital reserves that we hope may not be needed but are there in case of overrun. The second thing is that we would be thinking about milestones quite carefully. So when we commit to fund a case, we're not just sort of saying, okay, here's $5 million, tell us when it runs out. Typically what we're saying is, here's a commitment to fund up to $5 million in accordance with this budget and project plan that we've agreed to. And so, if we get to milestone 2 and we're at double where we're expected to be, we may not have run out of money because there's still plenty of capital available in the funding commitment, but we can see that we're on track to run out of money. And so hopefully there are opportunities for us to kind of get around a table and figure out solutions without being kind of 11th hour, the money's run out, scrambling, what do we do? If we're in that sort of budget overrun scenario, first question is going to be, are we happy to put more money in? And we may well be. If the economics warrant it and everything looks good, why wouldn't we increase our investment to see the case through? But we would also usually want to try and have some kind of agreement with counsel. Sometimes we have counsel that will say to us, look, if we have this level of funding commitment and we blow through the budget and we've got a margin for overrun and we blow through that, we'll see the case through on contingency from that point forward. You guys just fund the costs, for instance. So we might have an agreement, that's obviously something that's negotiable case by case. We might have an agreement in the deal that sort of specifically deals with that type of situation. But the short answer is it's a problem and something that we're alive to and we have to be careful about. And it's in everybody's interests, I think, to think carefully about it, because no one wants to find themselves in a situation where we're a couple months before trial, money's run out, everybody's looking at everyone else, in terms of who's going to put up the extra cash needed to see this over the line.
Well, I was also thinking it's probably a valuable service in a sense that you are keeping your eyes on that budget issue to make sure that you're doing projections and being aware of potentially running out of money. That could be a valuable service for the party.
I think so. Yeah. I think that's right. I hope people see it that way, that both from a law firm perspective and from the party's perspective, that this type of sort of budgetary scrutiny and project planning approach at the outset is in everybody's interests. Even if you were funding the case just on a the company was funding it from its own balance sheet without outside funding, we would strongly encourage them to have that type of conversation and be thinking along those lines as well. So yes, I certainly hope that everyone would agree that it is a valuable and a useful thing.
Yeah. Doing. We're almost out of time, but I wanted to see if you have any stories that you could share. Commercial litigation is notorious for often dragging on for years and years and years. Have you had any, cases that you've been involved in that have gone on for tremendous long lengths of time? Yes,
yeah. Quite a few actually, and probably more than I would have ideally liked to have. But there's one. I'll be careful how much I say about it, because actually still pending.
Of course,
unbelievably. Right? But there is one matter that always comes to mind when people ask me about the longest running matter. So it was a matter that we actually first got involved in 2009.
Wow.
It took until 2012 to actually conclude it was a combination of a funding insurance deal for a fairly sizable group litigation matter in Europe, and took us until 2012 to actually execute on the deal, which was like a world record in itself.
Yeah.
And the case is still going.
Wow. And we're recording this in 2021. So
2021, it's still going.
11 years later.
Yeah, there's an appeal. There's an appeal on a specific point, which is hopefully going to be handed down, or a decision on that appeal, I should say, is going to be handed down imminently. And then once we have that, then we kind of know if we're still alive and if we're still going to what. So it's not even like I can say that there's much light at the end of the tunnel in terms of resolution. And I think actually that this was in a jurisdiction, it's in a European jurisdiction that
I have one in mind that, that it could
it's
be.
Actually probably not the one you think.
Oh, really? Okay.
It's one that, and I think it goes to the point you raised earlier about subject matter expertise. But it's a jurisdiction that, frankly, we and the others involved didn't know an awful lot about, and I think we sort of went into it with a certain expectation on timing, that it would be fairly quick and easy process, and it's been anything but. So
my money's on like some obscure one, like Luxembourg or something like that. But you don't have to respond to that. But are there any jurisdictions like, I don't know, Italy or something like that you just don't get involved in?
Not as a matter of sort of strict policy. I mean, Italy was obviously the one everyone would think about, right, in terms of very long running process. So clearly we would want to think about that. I think the way I would look at it is it's really about just kind of knowing what we're getting involved in. I mean, for example, one of the areas that we're quite actively involved in is investor state arbitration cases, under ICSID, for instance. And those cases, can
what is that exactly?
So those are cases where an investor is actually bringing a claim against a sovereign state under a bilateral investment treaty between the sovereign state where the investor is based and the state in which the investor made its investment. So, for instance, somebody, U.S. investors might make a investment in an infrastructure project in a Latin American state, for instance, and then an organ of the state expropriates the facility or otherwise causes the U.S. investor to lose its investment. They may have recourse under the bilateral investment treaty between the US and the state in question, and may be able to bring a claim against the sovereign state. So, and it's an area that's pretty busy for litigation finance, because you very often get very sizable claims, but you very often get investors that lost everything in these projects and need outside funding in order to pursue these cases. And these cases, are run under an arbitration procedure, and they can take an awful long time. There's often a bifurcation between the jurisdiction and the merits phase. There's often annulment proceedings or set-aside proceedings at the end of the process, sometimes expensive enforcement. So, these things can take years and years and years to resolve. And that's fine. I think, the issue is just simply knowing that that's likely to be the case, and making sure that the funding terms reflect that, both in terms of the budget and the return. So, to your point earlier, no, there's nothing we wouldn't look at, but, we would just want to go into things with our eyes open and
sure,
make sure that the deal is structured accordingly.
Well, James, this has been great. Thanks so much for giving us such a great overview of litigation financing and how it works and what sorts of areas of the law where it comes into play. Tell everyone where we can learn more about you, learn more about Erso Capital.
Great. Thank you very much. Yes. So you can visit our website, which is ersocap.com, ersocap.com, where you can find some information about the funding arm of the business. And then the insurance arm of the business, is called TheJudge Group, and the website is thejudgeglobal.com. or one word, judgeglobal.com. And you can find information there about what we do on the insurance side. And actually the Erso and Judge websites are linked to one another. So there are links for one to find your way to.
James, thanks so much for your time today.
My pleasure. Thank you very much indeed, John.
Thanks for listening to Engaging Experts. Be sure to click subscribe so you don't miss our future episodes.